Gratitude to the leadership of the House of Representatives and the Constitution Review Committee for the privilege afforded me to offer a few remarks at this highly important event. I commend the committee and its development partners, particularly the Policy and Legal Advocacy Center, PLAC, and the Foreign and Commonwealth Development Office, FCDO, for organizing this retreat aimed at unearthing wider input towards a constitutional amendment that will deepen democratic and judicial reforms. The process of enacting or amending a nation's constitution is a solemn exercise that calls for logical reason and deepening an analysis in view of the sacred position which the Constitution occupies in the architecture of governance. The constitution of any country is what is usually called the organic law or the ground norm of the people. It contains all the laws from which the institutions of state derive their creation, legitimacy, and very being. The constitution is also the unifying force in the nation, apportioning rights and imposing obligations on the people who are subject to its operation. Furthermore, the function of the Constitution is to establish a framework and principles of government intended to apply to the development and governance of the nation. The 1999 Constitution of the Federal Republic of Nigeria, since coming into force on 29th day of May 1999, has been subjected to amendments at various times, which are now known as the first to fifth alterations. However, the quest to strengthen our practice, principles, and institutions of constitutional democracy continues to elicit the need to tinker further with the Constitution. Indeed, some eminent Nigerians, amongst and legal luminaries like Chief Emeka Anyaoku and that world-renowned jurist, Chief Affirmed educationist, Afro Babalola SCN, and so on, have continued to make a case for the enactment of an entirely new constitution. Whatever it is, no constitution is perfect in the sense that it does not provide an all-encompassing or everlasting solution to all societal or national problems and challenges that may arise. It is a living document that embodies a people's collective covenant for the present and long into a nation's future. It is as much an assurance that it promises unsettled expectations that will be kept, and as yet it is capable of advancing our aspirations to a greater future. The Constitution is expected to evolve and or develop further as the society grows or develops through periodic restatement and amendment. By periodic amendment, I wish to say that it is better to have a bad law administered by good men than to have good laws administered by bad men. It is therefore glad that the House of Representatives in the 10th Assembly has chosen to be super proactive and responsive by embarking on the current amendment exercise to bring the Constitution more in alignment with the will of Nigerians and improve democratic governance. The foregoing is underscored by the thematic issues which this retreat and the proposed amendments are designed to cover. They span electoral reforms, federalism, the evolution of powers, police, security, local government autonomy, public revenue, among others. An area of pressing pain is in the strengthening of the judiciary with respect to capacity, output, and streamlining problematic areas of appellate processes in interlocutory appeals, limiting such access and prescribing timelines or time limits for their disposal as in election litigations, addressing overlapping jurisdictions of the court of coordinate status in borderline cases, appointment process, and regulatory framework fast-tracking adjudication in threshold investment disputes of significant impact to meet economic realities? Can the superior courts, for instance, be empowered to have their own judgment enforcement and execution machinery that do not require executive assistance or intervention, thus further enhancing independence of the judiciary? I must, however, state that the salient issue of constitutional amendment should not be reduced to a mere legislative routine or ritual. The focus should be to providing remedy to our governance and developmental challenges. Some previous amendments failed to achieve the desired impact on account of inadequate consultation, deficit of introspective impact analysis, lack of sincerity driven by personal interest, and other extraneous or non-altruistic considerations. For example, many states are yet to take advantage of items that were recently moved from the exclusive to the concurrent legislative list. Nothing is happening. Where lies the oversight function of the National Assembly? The driving force of every amendment of our laws must be anchored on the twin pillar of advancing the cause of democracy and national development. While shared wisdom from practices or convention obtainable in foreign jurisdictions is not in itself to be gainsaid, we, as a sovereign nation, must not be conscious of our peculiar identity by blind adoption. We should not close our eyes to peculiarities that we have by blind adoption of foreign constitutional models and precepts just to gain their validation. Nigeria is a federation, no doubt, but it is one with its own unique history, culture, tradition, and practices. Hence, the constitutional amendment effort must be directed at infusing us with a sense of ownership. It must be an amended constitution that aspires and adapts itself to the need to develop solutions that are endogenic and autonomous and respected because it suits and positively reflects our peculiar local and national circumstances. It is also my charge to this august committee to ensure that the structure and system of governance at the subnational levels are strengthened and enabled to achieve their rightful purposes. Relatedly is the issue of autonomy for local government in Nigeria. I am very pleased to note that after 10 years of persistent and checkered clamor for financial autonomy for local government, the Supreme Court yesterday, in a bold move, delivered a landmark judgment which granted full financial autonomy to the third tier of government. The legal work leading to this eventual victory was driven by the desire of the current administration to promote good governance, stimulate the welfare and development of our people, enhance peace, and combat insecurity at the grassroots in line with the constitutional mandate of the government. May I now proceed to the interrelated issue of the legitimacy of local government elections being conducted by various state independent electoral commissions. This is a fundamental issue which should attract the attention of this committee in providing further consequential constitutional safeguards for the administration of local government. Aside the notorious fact that the ruling party usually sweeps all the available chairmanships and councillorship seats, there have been unfortunate instances where opposition candidates who manage, and I say strayed, to emerge winners, strayed in quotes, to emerge winners are not sworn into office. There is also the need to introduce measures to ensure uniformity and security of tenure for local government officials across the country. For instance, you have tenure for every official pegged at 4. But the state governors have weaponized the issue of tenure. So unless you do something, we will not move. And let me also share this, that the reason we went to court on the issue of local government, and which you all know, very few people here, either of the National Assembly, will dare their state governors if they ask you not to amend the constitution to allow for autonomy. If you do it and you succeed, if you have the Govt, you are not coming back. But this is the time to prove that you are in charge. Okay, we will see when you come back. Furthermore, I urge the committee to look into the challenges confronting the running of the affairs of governance structure across the states of houses of assembly in Nigeria. Since assuming office, I have been engaging stakeholders on some critical mutual areas requiring constitutional review, which exercise has produced some draft constitutional amendment bills for consideration by the National Assembly. The Federal Ministry of Justice, in collaboration with the Nigerian Bar Association under the leadership of Mr. Michael OON, the president of the Nigerian Bar Association, organized a national summit on justice in April 2024, which dwelt extensively on some of the thematic issues coming out for deliberation in this retreat, especially in terms of judicial reforms and administration of justice generally. It is hoped that the collaboration among the committee, the judiciary, the Federal Ministry of Justice, and other critical stakeholders will go a long way in providing the required synergy to address these pending problems. I will shortly hand over the draft bill arising from the conclusion of the Justice Sector Summit to the authorities of this committee. In closing, I also enjoy the committee to be guided in the discharge of its assignment by major themes of unity in diversity, fairness, justice, freedom, and so on, that run through our new national anthem. I wish to reiterate my appreciation of this distinguished committee and all participants for this unique opportunity and for granting me audience. May this patriotic retreat prove to become epochal reference point and yield the desired outcome. I would like to thank you for giving me the platform. Thank you.